I will state for the record, I did watch her arraignment this morning via the live stream because I was curious what was going to happen. And it did appear that, to me, it looked like she may have been nodding off at times, but I'm not sure about that. So I can understand where the court was coming from with that.
All right, our next Williams, this is case number 25-14094 FH. Appearances from counsel.
Joanne here for the people.
And I'm Jeff Harrison. I'm here on behalf of Ms. Williams. As you may have already noted, she appears electronically from the Webster County Jail.
All right, thank you very much. Ms. Williams, are you able to see and hear?
This isn't just a routine bond violation hearing. Jennifer Williams is facing serious accusations with a surprise twist. A failed drug program enrollment, new charges, and a courtroom already questioning her state of mind. Things are about to escalate.
For your arrest, it was based upon an order that you had failed to enroll in drug testing as a term or condition of your probation. I'm sorry, of your bond or your pretrial release. One moment. Then additionally, we had a show cause for your failure to enroll in that program, and it looks like you failed to appear on that date, which was August 1st. Now, when someone fails to comply with the court order, it could be treated as a matter of contempt, for which a defendant could be sentenced up to 93 days and or $7,500 in fines and costs. The court recognizes before it, also here in the back, Ms. Alex Matsky from the Western Missaukee Community Correction Program. So, Ms. Williams, we're not going to treat this as an issue of contempt. However, the court chooses to use it as a review of your pretrial release conditions, or in other words, your bond conditions. You have the right to challenge this allegation at a contested hearing and have the prosecutor prove the allegations, which could even be done right now if we so chose. At that, you'd hear some witness testimony. You could cross-examine that witness. You could also present witnesses' evidence or testimony if you chose to do so. And of course, you'll be represented by your defense attorney at that hearing. Again, the court must give you some due process. Now, if you're found to be in violation of your bond conditions, your bond conditions could be modified, continued, or bond could be revoked and you could be remanded into custody. Now that I've told you what the allegations are, what your rights are, and the possible consequences of your choices, I'm going to turn to Mr. Harrison. Mr. Harrison, how does your client wish to respond at this time, sir?
At this point, Your Honor, we would, in light of the fact that she's also set to be arraigned on new charges, at 1:30 today, we have no option, frankly, but to do something to contest the bond violation at this juncture as well.
Okay. Well, we have a couple options there. Right now, we're at 9:50 a.m. We could proceed today and take testimony, or...
I don't have my file. I didn't know she was going to be arraigned up here today. I do have the new allegations.
All right.
But I was just brought
I don't think it'll be terribly necessary to resolve this today, Your Honor, unless the court deems it so.
No, it's okay. I don't think the testimony is very complex. It might take all of 30 seconds, but the court will set it for a hearing.
I don't even have the sheet in front of me. I do have the new allegations. I just signed it.
That's okay. So is there another allegation that she test positive?
She had a pipe.
Oh, she had allegedly had a meth. So that will also be dealt with at the hearing. Plus, I'm going to note that I'm concerned.
Right. Okay.
I'm concerned with Ms. Williams' ability to comprehend what's going on, because it appears to me that she is under the influence of some substance based upon her demeanor and presentation today via Zoom.
And a similar concern was raised by jail staff this morning, so I feel more comfortable not pursuing.
When a judge pauses proceedings over concerns you are under the influence, that's a major red flag. Do you think this call was about protecting fairness, or was it a sign the case was already leaning against her?
For a hearing. In the meantime, the court is going to deny the defendant bond and remand her into custody until the hearing. Thank you very much. We are adjourned.
Thank you.
Later that day.
I'm sorry, person at the jail, what is your name?
Jennifer,
Williams?
yes.
This is case number 253631 FY, the people of the state of Michigan versus Jennifer Lee Williams. We are here for an arraignment. Ms. Williams, did you have the opportunity to meet with somebody from the defender's office today?
Yes, sir.
I have a complaint that alleges that on or about August 8th, 2025, in the city of Cadillac of Wexford County, in count number 1, it is alleged that you did commit the offense of possession of methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. In count number 2, it is alleged that you did commit the offense of police officer assaulting, resisting, or obstructing, in particular Sergeant Zach Hicks of the Cadillac City Police Department. That is a 2-year felony punishable by up to 2 years in prison and or $2,000, and consecutive sentencing may be imposed if it happened in a place of confinement. In count number 3, it is alleged that you are a disorderly person who is found jostling or roughly crowding people in a public place. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $500. In count number 1 and count number 2, the prosecution has also elected to charge you as a habitual second offender. That means that you have at least one prior felony or attempted felony in your past. That makes the 10-year felony and the 2-year felony punishable by 1.5 times that amount. Do you understand those charges and potential penalties?
Yes.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present at any questioning that you consent to, and you have the right to stop answering questions at any time. You also have the right to be represented by an attorney. If you cannot afford one will be appointed to represent you, but you may be required to repay a portion of that expense. Do you understand that?
Mm-hmm.
That a yes?
Yes.
Today, do you plan to hire an attorney, request the appointment of an attorney, or represent yourself?
I need an attorney. I'd like one.
All right, the court. I'm sorry, I didn't hear that last part.
I'd like to have one appointed.
All right, the court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who committed the offenses. If the prosecution is not able to do that, the case would be dismissed. If they are able to do that, you'd be bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and an attorney from the prosecutor's office will see if there's a way to resolve the case short of going to trial. Do you understand that?
Yeah.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, and historically, I show a jostling in 2019, domestic violence in 20, in 24, a larceny less than 200, in 24, an attempted resist and obstruct. There was a 4A case back in 17. In 06, there was an MIP of alcohol, 22, an operating while visibly impaired, and 25, a trespass. It's my understanding that she has a bond violation out of the circuit court for I think it was a drug charge and possession of contraband, if I remember correctly. My probable cause affidavit that I read today indicates that she was maybe in absconder status in the circuit court. And I know there was a bond arraignment or bench warrant violation arraignment today in which was set for a contested hearing, if I remember correctly. Probable cause affidavit also indicated that looks like there was an attempt to apprehend her by the bounty hunters, so to speak, looking for her. Any comment regarding bond defender's office?
I apologize. I wanted to make the court aware that the circuit court, according to her, I was informed by Mr. Eichel, the circuit court did not accept any plea from her today because she appeared to be under the influence of something to them. I spoke with her about an hour ago, and that didn't strike me to be the case. So I just wanted to make that statement.
I will state for the record, I did watch her arraignment this morning via the live stream because I was curious what was going to happen. And it did appear that, to me, it looked like she may have been nodding off at times, but I'm not sure about that. So I can understand where the court was coming from with that.
Okay.
But
I will just say I would be comfortable with the state of mind that she was in at least an hour ago, and assuming it's remained the same with proceeding as usual. I would like to say that the incident, at least where she was picked up here, I don't know, I feel as if mentioning it because I found it sort of unique.
That arrest story is brutal. Being lured in by the promise of seeing your child, only to be cuffed? It's messy, emotional, and raises real questions. Was this necessary, or did it cross a moral line?
Some substance based upon her demeanor and presentation today via Zoom.
And a similar concern was raised by jail staff this morning, so I feel more comfortable not proceeding today.
All right, thank you very much. Now, I did note that Ms. Williams appeared to make a comment. I did not hear that comment. I'm going to ignore.
That being said, she does have a support network that's growing here in the city. She has a partner who she would like to stay with. And then she also has I wouldn't say a job lined up, but work lined up at a house that she can stay in. So that would also take care of housing. She wasn't able to give me the address for that, but it did sound credible to me. So thank you.
I should have also mentioned that the praxis scores her at a risk level 8, which is a high risk. Is there anything about that you wanted to address? I know you already addressed the housing issue and the lead on work.
No, Your Honor.
All right. Ms. Lawrence?
Thank you, Your Honor. I don't think I need to go into too much detail. As the court stated, they read the affidavit on this case. I think it's pretty clear the defendant cannot be successful on bond since she is on bond in circuit court for another possession of meth. And she picked up this new possession of meth while on bond, and also her failure to appear in circuit court as well. Given that, and also the fact that this did happen in a public place, a very busy place at the G&D party store in the parking lot, I do think there are some concerns for public safety in this case. I would ask for random drug testing as well as a $10,000 bond. Thank you.
What was her bond in circuit? Do you remember?
I believe I was told she had a remand.
No, but before she absconded. In my mind, I thought I had changed her previous bond to $25,000.
It looks like it's 25,000.
25,000. All right. All right. The court finds that Ms. Williams presents as a flight risk in that she was absconding from circuit court bonds, and by the praxis, it looks like for over a month, and that she had failed to enroll. I assume that's in testing, at least based on the findings in the probable cause affidavit that I had to review in order to find probable cause for the charges today. It does appear that she was trying to be apprehended by the bondsman's bounty hunters, and it was not going so well for Ms. Williams. So I do find that she is a flight risk. I also find that she's a threat. I am going to order a $50,000 cash or surety bond, since the $25,000 didn't keep her coming back to court or following the bond conditions, allegedly. Ms. Williams, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any illegal controlled substances, including recreational marijuana, and you'll be subject to random testing. On the situation that you are released from jail, I'm going to order that you be placed on a GPS tether for location purposes only. Anything else you think would be appropriate in a pre-release order, Ms. Lawrence?
Actually, Your Honor, I would like to ask for a no contact order with the G&D party store as well.
Was she creating a disturbance there, or is that just where everything happened to go down?
The defendant was yelling and screaming in the parking lot. I believe the complainant who called it in was likely a customer of the G&D store.
But it's not like she went there specifically to create an issue. That's just where it seemed to happen at.
I believe so.
All right, I'm not going to order it.
In the end, a $50,000 bond, drug testing, GPS tether, and strict conditions show the court's zero-tolerance stance. What's your take on this ruling? Drop a comment, hit like, and subscribe for more dramatic courtroom moments.